Larry Lala here with another video case brief, the famous International Shoe versus Washington. Here's a quick overview. I'm going to give you a quick background for the case so that you can understand the context of the standard or rule that comes out of it. I'm going to tell you up front what that standard or rule is that you're supposed to get out of the case so that you start immediately with what's important about International Shoe. I'm going to tell you a bit about how to use it on a future exam, because that is what's ultimately important. But even so, I'm going to give you an illustrated factual and procedural background on the case so that you can survive in class, who the parties are, what happened, and what the holding is. So here's the quick background to International Shoe. The context of Shoe is that this is a case about personal jurisdiction, the court's power to actually make a defendant show up and have to defend a case over a corporate defendant in a civil lawsuit. Before, you can imagine hundreds of years ago in England, mostly cases were against natural persons, flesh and blood people, and they were either in a state or they weren't, and they could be dragged to court. Later, it was less barbaric to use summons or notice, tagging that person with a piece of paper saying, hey, you have to show up to court. But you can imagine that that could have been used abusively to make someone show up to a court in a state that they'd never been in just because someone they'd wronged lived in that other state. The use of notice or summons then became subject to due process. Now, this is a really casual way of stating this, but it's more or less true. The next wrinkle is that you end up moving from flesh and blood people to legal persons such as corporations. And International Shoe is an early attempt to deal with corporate personhood. By 1945, when Shoe was decided, personal jurisdiction was determined by both state law, authorizing state courts to grab either natural or legal persons, and the constitutional limitations subject to the Due Process Clause. Here's the standard. International Shoe is about minimum contacts. That is, usually corporate, but also natural person defendant, must have minimum contacts with the state in which it's being sued for that court to have personal jurisdiction over it. This means that if there are continuous and systematic contacts with the state, you have an office there, you live there, the defendant mainly does business there, it's clear that there's personal jurisdiction there. If a company only has a casual presence in that state, maybe it sends a person to go to meetings there or a conference once in a while, but doesn't transact business there, that's clearly insufficient for personal jurisdiction. The vast majority of cases are going to fall somewhere between these two stools. The other thing that's mentioned in the case is whether the contacts that we're talking about are related to the subject matter in the lawsuit also affects if there's personal jurisdiction. For instance, if the contacts are continuous and systematic but not related to the case, we're talking about general jurisdiction, and it's less likely that you'll find a court deciding that it has personal jurisdiction over a company. Whereas if there's a casual presence, but that presence led to the specific subject matter in the dispute, we're talking about specific jurisdiction, and it's somewhat more likely that there will be personal jurisdiction over the defendant. Now, this distinction is alluded to vaguely in International Shoe. It doesn't matter. For the resolution of that case, this distinction is raised there. Shoe is a specific jurisdiction case. How do you use Shoe? Basically, it's a mandatory shout out for any personal jurisdiction question. You set up a two-part analysis. First, you look at the state or sometimes federal long-arm statute, and then if that statute permits you to assert personal jurisdiction over a defendant, or if it's a state long-arm statute that permits jurisdiction to the extent allowable under the 14th Amendment Due Process Clause, then you jump right into the constitutional analysis. But you cite Shoe in saying that a defendant must have minimum contacts with the forum state such that the suit does not offend, quote, traditional notions of fair play and substantial justice. Then you cite a different case for the 14th Amendment convenience factors. This is a pretty mandatory shout out. Normally I say you don't have to cite cases in doing an IRAC analysis, but for personal jurisdiction, you gotta cite Shoe. Note that this case is not generally useful in actually resolving personal jurisdiction issues. It just sets up the standard. Now, what happened in this case? Shoe occurred during the New Deal when unemployment insurance was first coming up. Now, here we have a bunch of guys with no jobs. And then the state of Washington passed the Unemployment Compensation Act. Any employer who has employees in the state of Washington must pay a tax to the state of Washington to set up and fund an unemployment fund. Those tax dollars go into the fund, and then the fund then helps those people who don't have jobs. The state of Washington has a commissioner that then may go after those companies that don't pay their unemployment taxes. International Shoe is a company that's headquartered in the great state of Missouri and is incorporated in the great state of Delaware. The question is what contacts this company had with the state of Washington. This was the extent of International Shoe's operations in the state of Washington. It had 11 to 13 shoe salesmen. Now, these salesmen lived in the state of Washington, but International Shoe had no offices in the state of Washington. These salesmen would generally meet people in hotels or in their homes. These salesmen also had no authority to make contracts. They would send orders to Missouri headquarters here for the contracts to be made. There was no inventory kept in the state of Washington. Shoes would be shipped after the contract was made in Missouri to those people who purchased in the state of Washington. And in fact, the salesmen walked around with samples. They simply showed the shoes but had no authority to give them to people. There was no salary. These salesmen were paid on commission, but the salesmen did pretty well and drew $31,000 a year in sales. This here is a death of a salesman quote. I'm not well liked. Now, that's obviously more of a Dustin Hoffman than the big blustery Brian Dennehy. This is all relevant because it was a very deliberate act on International Shoe's part to minimize the contacts it had with the state of Washington. Based on all of this, someone at Shoe headquarters in Missouri decided that they did not owe taxes to the state of Washington's unemployment fund. The state of Washington did not like this, so the fund strikes back and sent Shoe a delinquency notice for all the years it did not pay into the unemployment fund. So those are the parties, the great state of Washington versus International Shoe. Here's the shoe, here's the international part. And basically, this is the dispute. Give me my damn tax dollars. And Shoe says, I don't know who you are. A couple of guys sell shoes there, but they can't do anything. Here's the posture of the case. Shoe makes a special appearance before the Washington Office of Unemployment to contest personal jurisdiction. A special appearance is one where you don't concede. You make the appearance specifically to challenge jurisdictional issue. You're not appearing as a defendant to actually defend the case on the merits. So both the Office of Unemployment and an administrative tribunal that's set up under the Washington law say, yes, you are subject to personal jurisdiction. Shoe appeals this to the trial court, and then to the Washington Superior Court, and then to the Washington Supreme Court. And all they say, yes, absolutely, the Office of Unemployment has personal jurisdiction over Shoe. Shoe still doesn't like this, so they appeal to the United States Supreme Court. And in a unanimous decision, the court decides that there is personal jurisdiction. There's an interesting concurrence, largely lost to history. Nobody cares about this, but it may matter when you're called on in class, where Justice Hugo Black says, yeah, there's personal jurisdiction, but this decision, the way we've written this, is way too restrictive to states in regulating whether or not they can assess taxes for activities that go on in that state. So here we have Chief Justice Harlan Stone, who says, yes, there absolutely is personal jurisdiction over International Shoe. Stone describes some of the standards that I mentioned up top in terms of minimum contacts and whether a company's activities are continuous and systematic or merely casual, and whether or not they're related to the issue at hand in the case. Applying these standards, the activities carried on in behalf of appellant International Shoe in the state of Washington were neither irregular nor casual. They were systematic and continuous throughout the years in question. They resulted in a large volume of interstate business. Remember the $31,000 in sales, in the course of which appellant received the benefits and protections of the laws of the state, including the right to resort to the courts for the enforcement of these rights. So what Stone is saying here is that perhaps if someone had purchased shoes from International Shoe, they could have used the Washington state courts to sue someone who, for instance, received the shoes but didn't make payment. I'm surmising here. The obligation which is here sued upon arose out of those very activities. So this is a call out to the specific jurisdictional nature of personal jurisdiction over International Shoe. It is evident that these operations established sufficient contacts or ties with the state of the forum to make it reasonable and just according to our traditional conceptions of fair play and blah, blah, blah. It's not unreasonable for the state of Washington to bring this case against International Shoe. There's some language here about the difference, what it means to have jurisdiction over a corporate person, since the corporate personality is a fiction. It's clear that a person is either in one place or another, but that a corporation may be in multiple places at once. Here's Black's concurrence. He says, fine, there is personal jurisdiction here. In this case, I totally agree with you. Black's problem with the court's decision is that it was too restrictive in theory in the future. And Black's concern is not lawsuits generally, but the power of states to tax. Here he says Congress, pursuant to its constitutional power to regulate commerce, has expressly provided that a state shall not be prohibited from levying the kind of unemployment compensation tax here challenged. So Black believes that this very specific allocation of power to individual states to tax as they need to fund unemployment schemes should not be trumped by a vague due process argument given to foreign corporations. This isn't super important, but here it is if your professor asks about it. Here's some food for thought. Rethink the International Shoe case. What if, on top of the facts that we're given, that the salespeople are completely out of state, is there still personal jurisdiction? Keep playing with the facts until you get to a point, or can you get to a point under International Shoe where, say, these guys are in Lebanon and, I don't know, France. What is it that has to happen for International Shoe to have made sales in the state of Washington but not be subject to personal jurisdiction? Give me your answers in the comments.